Welcome to the Modern Arizona Podcast. We share the stories of people whose lives are shaped by the legal system in Arizona and beyond. Each episode blends real experiences, expert insights, and practical guidance to give you a deeper understanding of the law and its impact on everyday life.
Hello and welcome to the Modern Arizona Podcast. I'm your host, Billie Tarasio, today joined by Lindsey Jackson. Lindsey is our new estate planning practice group lead. Lindsey, welcome to the show.
Thank you. Thanks for having me, Billie.
Yeah, I'm so excited about this. The whole thing, modern law has always primarily been focused on family law, but there is so much overlap between estate planning and setting families up for success and traditional family law. So can you talk to people a little bit about your background?
Sure. So I have been doing the trust and estates wealth management fiduciary role for, over 16 years now. I started as a practicing attorney, drafting estate plan documents in private practice. And then I loved what I did, but I wanted to get, more into the meats and potatoes of it, without having to worry about being on the clock with the billable hours. So I ended up transitioning to wealth management institutions, so corporate trustees and the like, and worked for over 10 years in that. On that side of things, administering trusts and estates as trustee and personal representative, also consulting with clients, helping them craft their estate plan in a manner that will actually achieve what it is that they're looking to accomplish. The biggest piece of that being once mom and dad are no longer here, and the actual administration and implementation of those trust documents. I spent 10 years doing that, and then realized that I was having difficulty finding great drafting counsel that really took a holistic approach to planning. And what I mean by that is understanding what the document actually looks like when it comes time to administer it. There there can be somewhat of a disconnect sometimes between the drafting and the actual administration. So I decided to go back to private practice and do my own thing. A little over a year ago. And I'm now working with clients, counseling them on both the upfront planning part while they still have capacity and still are young and maybe young families, and putting plans in place. As well, I'm also working with clients that have reached the realization event, if you will, of their estate plan, and have trusts that have become irrevocable, that are now being administered, and maybe the current provisions aren't as workable now. So there's mechanisms to assist clients through the administration of trusts like that too. So kind of tackle the issue from a couple different angles.
I have noticed since starting to get involved in this practice area is just how messy and complicated it is, and how the documents are really, really, really helpful. And if you don't have them, it can really interfere with your ability to help your loved ones.
Absolutely. That is sometimes what referred to as, incapacity planning, or
Mm-hmm.
diminished capacity planning.
Mm-hmm.
And historically, if, let's say, your spouse gets hurt or gets into a car accident and then becomes, unable, obviously, if they're in the hospital, they're laid up, they can't pay bills, can't file taxes, can't really handle all of those day-to-day matters that they ordinarily would. um, you know, technically speaking, unless you have a valid power of attorney in place that grants an agent the ability to do those things on your behalf, technically speaking, you could be hosed, for lack of
Yeah.
better words.
So I want to talk about that.
Yeah.
You have a neighbor who's struggling, or your mom is struggling. And I know my mom helped her mom pay her bills. You're spending somebody else's money.
Right.
without legal authorization. What can the consequences be of that?
So that has been a widespread issue in Arizona, also in Florida. The Sunbelt states, where we have a larger retiree and older population. Elder financial abuse is a real issue. Now, I I would say more often than not, there's nothing nefarious going on. But unfortunately, I would say with more frequency, there are shenanigans that are taking place where, particularly with the advent of online banking and the ability to do a lot of things electronically without necessarily having to have that person be present, there there can be some bad actors that get involved. But ideally, you will have a durable financial power of attorney in place that names a trusted individual to make those decisions on your behalf. And Arizona actually has somewhat criminalized, to a certain extent, elder abuse. There are criminal penalties for folks who are deemed to be taking advantage of folks with diminished capacity. So it's a very big deal, that can have dire consequences. Um, but to the extent folks have properly planned, it's a non-issue.
Yeah, so the risk here is, let's pretend, my mom's helping her mom pay her bills, and she has, a sister who thinks that she's spending the money wrongly. That didn't happen, but let's say that happens in a family.
Hmm.
You now have the sister saying, this sister spent too much money on mom and wasted my inheritance. That's elder abuse, or like what is what it looks like, what happens after, my grandma, dies.
Sure. So, the elder abuse realm, in terms of the legal aspect of it, you can file those, or complainants can bring those concerns to the court during a person's life or after they've passed.
Mhm.
Um, the basic requirements are is you have to have a person who is in a position of trust and confidence
Mhm.
with the person who is allegedly being financially abused,
Mhm.
and they are utilizing the potential abused person's assets not for their purposes, but they are using them to benefit themselves.
Sure.
So essentially, the person that is helping
Yeah.
mom or grandma is in a fiduciary position with regards to the person they're trying to help. And what that
Right.
means is that person has to be on their absolute best behavior. Those funds are not theirs personally. They have to always be acting in the best interest of the persons whose funds they are, and cannot personally enrich themselves. Um, some may argue that such a person receiving compensation for helping mom or grandma could potentially be seen as personally enriching the agent. It's interesting. One modification I've made in my personal estate planning documents is that I make it very clear that uh, the family member receiving compensation darn right they should be receiving compensation, because if you've ever been in that position, it is a thankless a thankless role, and it is all consuming. Um and but at the outset, acknowledging this is not something where the agent is abusing the access to the principal's funds, because mom is authorizing, yes, I want you to be able to get paid for helping
Yeah.
me.
Okay, so let's talk about that. There are so many adult children who are caretakers for their parents,
Mhm,
and many of them are not receiving compensation.
mhm,
But there's often this thought about, should the person who was the caretaker get more of the inheritance,
mhm,
or XYZ?
mhm,
Let's say in that situation, the adult,
mhm.
the who is being taken care of, has some diminished capacity. They need help taking care of themselves. Is it too late to put together an estate plan and figure these things out?
Absolutely not. Absolutely not. The so what we're talking about is the individual's capacity to create an estate plan. That's testamentary capacity. The one positive is that the standard, or sort of the bar for testamentary capacity, is actually lower than the capacity to contract.
Hmm.
Um, which means that you can have less of your faculties with you, and still have a valid estate plan, but maybe not necessarily have a valid and enforceable contract. And it's
Interesting.
quite simple. Uh, the threshold, or sort of the rules for determining capacity, is you have to understand the nature of your bounty, i.e., who are your kids? Who, do you have grandkids? Or have children past predeceased? Who is it that you're looking to benefit? You also have to have a basic understanding of your assets. What does your estate look like? That does not require that. Oh, yes, I have a balanced portfolio and my ROI last year. You don't. It's not to that extent, but understanding. Oh, well, I'm living in an assisted living facility, but we have a family vacation home up in Pine Top, and I have a retirement account, or I have brokerage accounts, and just having a general understanding of what your estate is made up of. And then also being able to communicate clearly who it is that you want to have benefit from your estate when you are no longer here. So those three things, and it can wane. It waxes and wanes. A person could have capacity to execute an estate plan one day, and maybe a couple of weeks later, they're not having a great day, and particularly late sunsetting, I think is the term. Later in the day, folks
Yeah.
have more struggles with memory and things
Mhm.
like that. So it's
Mhm.
it's very fluid.
Mhm.
And so just because you may have someone, a family member, daughter, niece, what have you, acting under a financial power of attorney to help a person with their finances, that doesn't necessarily mean that they are prevented from making changes or creating further estate planning documents.
That's important for people to know. So just because you give a power of attorney or you allow somebody to help you and you formally acknowledge that does not mean you're giving up your right to make your own decisions.
Correct. That's a very, very important distinction. I have a perfect example of what that looks like in real life. I had a client. They unfortunately did not have a revocable trust, but they had straightforward wills and powers of attorney. And this was when I was at a wealth management institution, and the client had her retirement accounts with us, and husband was wife's agent under a valid power of attorney. And so we could accept direction from husband in terms of, please transfer funds, that, please, and, sell this holding and invest in this. Um, but that did not preclude wife from also giving us directions, um, to the extent that that she seemed to have capacity and to be with it and make valid requests of us. Just because her husband could act under the power of attorney did not preclude her from acting. And we were this client, unfortunately, was a severe alcoholic. And at one point, she had requested that we liquidate her entire IRA of like $350,000 and transfer the cash and put it into her checking account. Now, she came up with some excuse for why she needed it, but everybody knew that she was going to spend it on alcohol, unfortunately. And so that the husband was really in a tough spot, because he told us, he's like, you can't take her direction. Well, actually, we have to if it's
Wow.
valid. Had and it was a retirement account, so that's a different wrinkle because you don't fund revocable trusts with a retirement accounts during lifetime. But for like a regular brokerage account, if that had been in a revocable trust, then wife would have no longer been a trustee upon becoming incapacitated under the trust provisions.
Interesting.
So we wouldn't have she wouldn't have been able to give valid direction.
I don't think I quite understand. When can someone, like when you have this situation, you've got a partially incapacitated person who is still allowed to act on their behalf and somebody with a power of attorney, and there's conflicting advice, what happens?
It's usually up to whoever it is that you're trying to give direction.
Got it. So the fiduciary who is managing the funds makes the call.
Yeah.
Wow. Okay.
And I'll tell you that I would say the last 5+ years, um, financial institutions have become acutely aware of potential liability
Mm-hmm.
under those types of scenarios.
Mm-hmm.
And that is, if folks have noticed banks becoming a little bit more difficult to work with, or, making you jump through hoops and things like that. That's why, that's why they're terrified of being sued.
Okay. All right. Let's talk about the benefits of liability protection from estate planning while people are alive. So, how does having an estate plan in place protect against creditors being sued, that sort of thing?
The traditional revocable trust estate plan that is most common for folks during the clients, the settlors, those are the creators of the trust, say husband and wife, during their lifetime, the trust is revocable and they are serving as trustee. That provides no creditor protection whatsoever during their lifetime. And that is actually a common misconception.
Mm-hmm.
M- there are trusts that you can establish during your lifetime that will provide creditor protection. Those are irrevocable trusts.
Mm-hmm.
And generally, the owner of the assets will not have control of what happens to those assets. So it's usually within the discretion of a third party trustee how those funds and assets are managed. That scenario can provide creditor protection. The thinking is that if the owner of the assets can't access the assets, then their creditors should not have access to those assets as well. But if the owners can essentially do whatever they want, which is the case for a revocable trust during lifetime. The husband and wife are trustees, who is the party that acts on behalf of the trust. Then creditors, the theory is that creditors should be able to access those funds. Now, the most common scenario that does provide creditor protection in a revocable trust structure occurs upon the death of one or both of the spouses. So if we're creating shares for children after
Mm-hmm.
mom and dad have passed,
Uh-huh.
typically those, if they are retained in further trust, those trusts will be creditor protected. So
Mm-hmm.
that's why oftentimes we will recommend for clients when they're doing current planning, if they are older and they have established children, and let's say we know one child is a spendthrift, or maybe one child is in a high risk profession,
Sure.
maybe child is a physician,
Mm-hmm.
then professions, or if we think that there's a likelihood of a child being sued, or maybe filing for bankruptcy or things like that, then it's always recommended that folks retain shares for kids in further trust using a third party trustee that would distribute funds as their discretion sees fit.
Okay, so let's go through an example. Let's say
Yeah.
somebody they've been very, very successful, and by the time they pass, they're going to have $10 million. And they want to give the money, let's say, to their grandkids. But, one grandkid is really financially irresponsible. The reason I'm using grandkids is because usually by the time parents are, people are 60 or whatever. But even if they're 60 and they don't have their finances in order, and
Mhm.
the person who has the $10 million wants to be able to fund housing or like specific things, but not hand over the money to the gambler or the
Yes,
alcoholic or whatever.
exactly.
How do you do that?
Discretionary trusts. So, and that it was the majority of the work that I was doing at financial institutions, serving as a third party, neutral, independent trustee.
Hmm.
Uh, so the way that you would do that, and the beauty of this world is that, unless there are, estate tax concerns, which at this point, it takes about $30 million
Oh,
plus per couple to have those concerns. So for the vast majority, we don't. That's not an issue. You can, the sky is the limit in terms of how you want to structure these discretionary trusts. So, for instance, if you have a child that is a spendthrift, what I would do as a corporate trustee is, if they were requesting funds from the trust, we made them submit a budget and tell us, this is the a full balance sheet and income statement, essentially saying, this is the money that I earn from my work or my job, investments. Here are my expenses. This is what I'm requesting help with. And when we would make distributions, we would prefer to pay expenses directly, right? Because then the dollars don't actually hit the child's bank account. So we would pay tuition directly to schools, universities. We would, set up auto payment of mortgages and things like that. And that way, there's not even a risk that that kids are going to dissipate the assets, because they don't even see them, but they're
yeah.
getting the benefit of the support on a monthly basis.
It seems like that is really important right now because we have all this money, right, that baby boomers are sitting on, and then there are, Gen Xers and millennials who maybe aren't as well set up. Maybe they're financially just not in the same place that their baby boomer parents were at that age.
I think studies have actually proven that
Yeah.
that for the first time in our country, the successive generation is not going to be better off. So you're absolutely right, particularly now.
Yeah.
I think it's important to really focus on that sort of next gen planning.
Yeah. Yeah, because it's not, I don't know, like, does that mean that millennials are not gonna be as well equipped to manage large amounts of money? My inclination is yes.
Probably. And that raises another great point too, is the money, yeah, and how people deal with money is very interesting.
Mhm.
And you treat and you deal with $100 very differently than you treat and deal with $100 million or
Mhm.
$100,000,
Mhm.
right?
Mhm.
um and one of the questions that always comes up when I'm consulting with clients in terms of structuring their estate plan is, well, how do I know? Yeah, I don't want to create a trust fund baby
Yeah.
and drop a big chunk of money on my kids. But if they've never handled money, how do we know what they're going to do with it? Or how will they respond? One of the suggestions that I make is that in these sub trusts that are created for the children's shares, give trustee the discretion to make a small percentage distribution to the child as sort of a test run.
Ooh.
um, See what they do with it, and then allow the trustee to sort of use those results in terms of informing future decisions. And so you can do that, with a 10% withdrawal rate upon child's request. You can do tiered requests. So, like I said, you can get as creative really as you want to. It's just important to make sure that it's actually enforceable and it's something that you could actually administer and implement. Surprisingly, comes up more often than I would think. Having sat on the bank side and
Right.
seen all of the documents. So,
Right. So the other reason that estate planning is recommended is to avoid probate. which is something everyone has heard, but not everyone understands.
Correct.
Can you
Correct.
can you explain that?
Absolutely. And this might be seem surprising to some people, but at least in Arizona, probate is not a nasty like five-headed monster that's going to, destroy. It's not that bad. Um Now California, completely different animal. I know that if you have to go open probate in California, you're stuck in court for at least 18 months. Their
Wow.
court and their I've had not great experience with their probate courts in terms of um, reasonable and sensible results from the judges there. Um, but in Arizona, the great thing is that we have somewhat of a bifurcated probate system. So in Arizona, you can file an informal probate, which, yes, you're filing papers with the court, but you never actually have to appear in front of a judge. You don't have to go to court. It's really just you're filing paperwork with the
Mhm.
court.
Mhm.
Um, and that process is it can be straightforward and pretty fairly simple. The Maricopa County court, they have tons of like self-service forms that people can do probate themselves. That's a lot, but it's possible. Um, so it's not necessarily this end all, this terrible thing. Now, that said, if you are going through informal probate, everything is public record. So that's
Mhm.
still not something that everybody or folks at least that I speak with are excited about.
Yeah.
Because they will file an inventory and then it's public record. People can see your assets, and if God forbid there's family harmony issues or conflicts throughout the administration of the probate, that is public record as well. So that is certainly a negative aspect of probate. But to the extent that it's a straightforward matter, you could in theory complete a probate in a year.
Mhm. That
Um,
still seems like a big chore after someone has died.
and that's the other thing. It is, and particular. I think one aspect of the probate experience that I think gets lost and folks sometimes forget is that y- you're in a really emotional time in your life. You've just lost a loved one, and life it looks different for
Yeah.
you going
Mhm.
forward, and there are deadlines that come up, and so if you don't have to deal with that hassle, obviously that's much preferred, but it is not it's not the death wish or a death sentence that some people uh think that it is.
Lindsay, thank you so much for coming on the show. What else do you think people really need to know about estate planning before we wrap up
Yeah.
today?
I would say everybody, everybody needs estate planning. And that was one of the reasons I chose this practice area. Life's two certainties, death and taxes, right?
Mhm.
And you don't have to have hundreds of thousands or millions of dollars to really need and benefit from an estate plan, particularly thinking about the impact that that has on your family. And I find myself counseling, becoming kind of somewhat of a therapist a lot of times when people are handling probate matters shortly after a loved one has died. So the misconception that you have to be incredibly wealthy to benefit or need or warrant estate planning documents, I really, really urge everyone to um, yeah, that's a misnomer and a misconception. Everybody needs it.
Okay, well, does everybody need the same thing though?
No, no. So it's a matter of degree, right?
Yeah. Yeah.
There there are, a revocable trust is not appropriate for everyone.
Mhm.
There are small numbers of beneficiaries and very simple assets, you can still avoid probate, without actually having to have a revocable trust. You can put beneficiary designations on bank accounts, or a TOD, POD designations, or transfer on death or pay on death designations. You can record beneficiary deeds for real property that say that on your passing, then the real property passes to, your children in these shares. And you can still avoid probate without having a revocable trust. So I, I I caution folks in um, accepting like the one size fits all,
Yeah.
because not every we're human beings and we're all different,
Yeah.
and I think that's an aspect of this that sometimes gets overlooked.
Yeah. So if we just start with like, if once you turn 18, you
Yes.
kind of need to give somebody a power of attorney.
Yes, beginning at whatever the age of majority is, it's in the state. Here it's 18. I know in Nebraska, where I was born and raised, it's 19.
Hmm.
Once, particularly for children that are now technically adults,
Yeah.
powers of attorney are incredibly, incredibly important, because mom and dad won't have the ability to come in and make these decisions on behalf of son or daughter because they're an adult.
Right. So if you get in an accident, or if you become an addict, or if something happens, nobody has the legal authority to swoop in and help you because you're not married. So you don't
Right.
have that like de facto agent. So you
Mhm.
really have to do that. You have no assets. So it's not like you even really need a will, right? You're
Right.
broke.
Right. Right. I had clients that had a daughter that studied abroad in undergrad, and thank God, we connected her with counsel and got a bunch of powers of attorney in a place before she went overseas. She got sick when she was
Mhm.
overseas,
Mhm.
and mom and dad needed to use those documents, and had they
Mhm.
not had them, I didn't even want to contemplate what would have ensued. But it's incredibly important that you have those things in place.
Yeah. So that's like the first threshold, right? Age of
Yep.
majority, you got to have somebody who can act on your behalf. When's the next threshold where, okay, the 18-year-old doesn't need the will.
No.
At what point do you need to have a will?
When
Do
you
you
have
wait until you have kids?
So that's what I was gonna say. I was gonna suggest, typically when you have children, definitely then you wanna get a will, because that is where you will name the guardians
Right.
and or conservators for minor children.
Right. And
So
if
that's
you don't, what happens? Who takes the kids?
then the state of Arizona gets to decide.
Okay. Yeah.
And
We
there's
don't want
Right,
that.
right? Yeah, just like it's like the intestacy statutes. So if someone owns property and they don't create an estate plan during their lifetime, and then they pass away without having a will or trust, then the state of Arizona gets to decide who gets what. And I will tell you, particularly in blended family
Mm-hmm.
scenarios,
Mm-hmm.
when there are children not of the marriage,
Mm-hmm.
that gets ugly,
Mm-hmm.
because surviving spouse doesn't get everything. So it's messy, and it's just, I tell folks, you want to have control over those decisions
Yeah,
and
if
not
you
have
have a
someone make.
blended family, you have to have an estate plan. Like
Absolutely.
it's a non-negotiable. You have to. So just give us a call. And then
Absolutely.
what is the threshold where somebody really should have a trust? Is it a net worth? Is it an age?
So there's, of course, there's not it depends.
Right.
It would be sort of a combination of all of those things. The thing to know, so probate threshold requirements in Arizona have just finally been increased for the first time in decades. Beginning in September, the end of September this year, an individual residing in Arizona at their death, to the extent that they own personal property, your stuff, your home furnishings, autos, bank accounts, that exceeds $200,000 and above, you have to file probate.
Got it.
For real property, it is now $350,000 net equity. So you would
Hmm.
take whatever the value is, less whatever mortgage you have on it,
Hmm.
and if that number exceeds $350,000, you have to file probate. So
Sure.
that's one sort of threshold value that I would look at. I also, if there are multiple beneficiaries,
Hmm.
that either, and there's real property. That's particularly helpful when to have a trust, because you don't necessarily have to. You can buy out shares, you can divvy things up and equalize, and it makes it a little easier to administer those assets and divvy up shares and things like that for successive generations. I would also say a blended family, absolutely. I would recommend a trust, 1,000%, particularly dealing with after one of the spouse dies. And if the children's situation is yours, mine, and ours, it's incredibly important to lay out in great detail what that family looks like, what shares are created, who is deemed to be a taker, and things like that. Um, in terms of the next step beyond that, then we're looking at estate tax and transfer tax thresholds. And the latest bill that passed, that the president signed into law on the 4th of July this year, that has done away with the sunset of the estate tax in 2026. So beginning in 2026, the estate tax exemptions, that means that an individual can pass up to 15 million, as adjusted for inflation, during life, as a gift, or at death, without paying his transfer taxes. So once you get around, I would say, close to that threshold for the estate tax, then that's completely different. That's the next step.
Got it. Got it. Wonderful. Lindsey, thank you so much for coming on the show and
Okay.
sharing all this information. I really appreciate it. And I'm so happy to have you at Modern Law.
Oh, thank you. It's been so much fun. I've loved all of the fact patterns, and it's been fun to help.
Thanks so much for listening to the Modern Arizona podcast. If you've enjoyed what you've heard today, make sure to download it, like it, leave a review, and share it with your friends. If you know someone who would be a good guest, or you would like to be on the Modern Arizona podcast, make sure to give us an email or reach out to us at mymodernlaw.com.